So I wanted to do a few introductions before we get to the main speakers today. I wanted to call out some of the people that you might know about, and so I wanted to start with Michaela. If you're an eState Planner user, you know Michaela. So Michaela's back there. We've got Greer. You may have spoken to Greer. We've got Yannick, head of marketing, and we've got Nick, who is the VP of eState Planner. And Lauren as well is here, I think, somewhere. So thank you. We also have some special guests. So I'm pleased to introduce one of our advisors. Mark Harris is here, and Mark was the founder of DivorceMate, and now one of our advisors at eState. And so we thank him for his support. And I think you sold off DivorceMate to some other company, didn't you? I don't know. Right. So thank you and welcome. So I want to introduce the panel. So Juda Strawcynski from Law Pro, he's the director of Practice Pro, was a litigator before he did that, worked at the Law Society, and really a really forward thinker on technology and error reduction, and as a member at Law Pro, really lots of hands-on experience with that. So Juda's going to talk to us a little bit about the kind of errors that we're seeing in our area and how to prevent them. Friedrich Blase is here, and Friedrich is very interesting. He was the OBA's Innovator in Residence. He's an advisor at the Legal Technology Ryerson, and he's also a real thought leader in this area of technology, not just in the States, but in legal tech, and he's probably seen it all. And so welcome. We have Ian Hull, who almost everybody might know. I don't know. Ian's, as you know, a founding member of Hull & Hull, and his dad was a great lawyer, and he's a great lawyer, and I'm pleased to call him my closest friend and partner. And Suzana Popovic-Montag, our managing partner at Hull & Hull. Both Ian and Suzana do a lot of Law Pro work, and so they have insight on when we get in trouble, how to get us out of it. And so welcome both of you, and thrilled to have you guys here. So I'm going to lead off, Juda, with you, put you on the leading off here. And maybe you can share with us some trends that Law Pro's seeing in errors in the estates field, and how those errors get caused. Maybe we'll talk about those two things, and I'll flip up a slide if you like.
Sure, thanks, Jordan. Curious what the slide's going to be.
You don't know, do you? Like, we keep this, we do our best to keep you hopping, and so I'm just going to, let's see which one I should. This was my vacation in Florida.
Oh, perfect. Okay.
Oh, look at this. That's pretty.
Perfect. Okay. Can everyone hear me okay? Awesome. So this is a lovely setting. Thank you, Jordy, for putting this together. And let's start with what I think you may have seen already, but Law Pro is the mandatory insurer. And so we see all of the mistakes or all of the claims that come in from lawyers around wills and estates planning or any other area of law. And that one of the benefits of having one insurer for lawyers is we have that data. We can see the trends because we see the entire pool. And what we do is our claims counsel, who for the most part have practiced in your areas in the past, before coming in-house to Law Pro, they'll look at these files and they'll work with external counsel when we need to, and they'll code these for what was the biggest mistake that we saw. Sometimes there's more than one, unfortunately, or sometimes it's sort of a judgment call because they're intersecting, sort of, some of these things are all related. But for wills and estates, this slide tells the story. This is what I lovingly call our wheel of misfortune. If you go to practicepro.ca, there is an area for our biggest claims by area of practice, and you can go and you can look at not just wills and estates, but if you're practicing in when you take inadequate investigation, time management, and communication, Those are all service side errors. Those aren't about you knowing the law or not knowing the law. This isn't about drafting necessarily, although we do see some drafting errors and error of law. But most of them are about serving your client and having those conversations with your client from intake through to end of retainer, where everyone is on the same page, where you've asked open questions, where you've asked deep questions, where you've done the work, and where everyone's on the same page from start to finish. So when we see these mistakes, what's inadequate investigation? It's simply not digging deep enough. It's missing things. And we know that some lawyers take wills kind of for granted. I'm just going to be honest here. We know that there is price competition. We know that there is a lot of pressure at times for some clients where they know that they could go and get a will online, and they could do that from who knows where, from a provider, with who knows what sort of expertise, if any, with who knows what kind of level of sophisticated internal logic to get there. But some people think, oh, I'll just do it myself. Some people think, oh, I'll Google it, I'll get a form, I'll put my name in instead of somebody else's. If it worked for Donald Trump, it'll work for me. I'll use this form here. We shouldn't be competing against those groups. What lawyers are providing is a 360 understanding of somebody's life's work when providing a will or doing an estate plan, and trying to protect it so that their interests going forward are reflected. And that's not something that those sort of, one and done, quick online solutions are going to be able to provide. But in order to provide that actual judgment, we need to ask the questions. We need to investigate. So we need to make sure that we're following processes, that we've got checklists, that we're asking about family dynamic. We're not assuming, for example, when somebody walks in with a spouse, that this is a first marriage for both of them. There can be all sorts of amazing concepts of family these days. So we can't assume anything. There are same-sex families. There are same-sex families or a child's interests where there are more than two parents who have rights, and where there are others who are also making plans. There are people who may have children from a previous marriage where the former spouse has a will that's going to protect somebody. And so this will might be taking those factors into account. The only way you will know is by asking. And, we can't skip over things, which is why checklists are such an important part of covering off inadequate investigation. NASA uses checklists. You've seen all those movies where they're going like this, check, this, check, this, check. They do it because it works. They do it because a checklist keeps you focused and makes sure you don't miss something like, something key if you're about to blast off, right? And it's the same thing here. You can't wing this. There's none of that from the hip litigator stuff that goes into making a will. You gotta follow it, right? You gotta follow it. And so inadequate investigation is where we're seeing a lot of problems. And that economic pressure, there were those pressures from a client. Why are you asking me? I thought you're on my side. Well, we're all on your side. We want to make sure that we understand your situation to protect your interests, right? And so that's where the inadequate investigation piece comes in.
Can I just jump in there? Is that a question of just not spending enough time? Is it a lack of checklists? Is it that we don't know what to ask? Or is it that, look, we don't have the time and we're not spending enough time? Do you have any sense on that?
So it can be one of both. We've seen cases where somebody has simply said, you want a mom and pop will? You want hologram? You want the reverse wills? His and hers special, away we go. I got that. Maybe 10 minutes in with the client, and then they pop it out, and lo and behold, there are key pieces missing from that. So we've seen that, but we've also seen people who are rushed. And this is one of the pieces around a diverse clientele, between language differences, cultural differences, and an aging population. Not just those who are necessarily aging, there may be a capacity issue, but there are others who may also have capacity issues. So we're screening for capacity, we're screening for undue influence. All of that takes time. And it may not take as much time as we had initially scheduled for. And the answer isn't to just like, cut off and print off what we got based on that. It's that we need to meet again. And so, during COVID, one of the things I was out there telling people is, those Zoom calls, how many times is it like, oh, I got to log in. Oh, this isn't working. Okay, 5 minutes gone on that. Then you can't hear. Then there's cutting out and all of that. So your hour with a client, that's not a real hour. That's not even like a psychologist's hour, right? Like this is like really, you got to make sure that there's a COVID cushion. And not just for the tech, but for the mental powers of doing this work. I mean, I remember getting my will, and it is exhausting. I don't want to think about my mortality. What am I doing here, right?
I wish I had a nickel for every time I said, can you hear me?
Yeah.
On Zoom. And I just had one of those today where by the time we actually started anything, it was a half an hour into the meeting. And I was like, I only got half an hour. So basically, you got to reschedule another meeting.
Yeah, and the client relationship, right? Like, how do you get people comfortable? Whether it's in an office, best case scenario, you're in an office, you're meeting face to face. Nice to meet you. Oh, you look professional. Nice to meet you too. You've got like my life's work in your hands. Let's chat about it. Let's chat about what happens when I die. That's an awkward thing for a lot of people, right? Like, that's a tough decision. That's a tough thing to talk about. You might have your spouse with you. You might be alone. There might be somebody who currently is providing you care, but there might be things you're trying to say that they might not necessarily want to hear. This is difficult work. That's best case scenario where you're in the room with someone. You put in the Zoom delays, you put in the rest of it, and you're chipping away at that time. In either case, one meeting may not be enough. Right? Depending on the sophistication of the client, depending on the sophistication of the asks in the will, right? This might not be a thing where, a preset formula of I'm going to spend X minutes per person will work. You might have averages in your firm about on average it takes me about this long to meet with a client, but that shouldn't be your hard and fast rule. And so inadequate investigation happens sometimes where things do get tricky. And sometimes it's the client saying, I don't want to give you that document. And then sometimes the lawyer's like, well, I think it's really important, but okay, you said you didn't want it. Well, guess what? If that client passes away and the executors look at this and say, what on earth, we're going to get a call.
What about, and this is a practical situation where, we have a bunch of, at eState, we have a bunch of users, right? 400 plus firms. And we do get a bunch of them that say, look, I don't collect any asset information. And that's just a sample size because there is a proportion for sure of lawyers who say, you know what, they don't want to tell me, and what do I really care? I'm giving all the residue to one person. What's the big deal? What do you say to those people?
Yeah, no. We've got materials online for limited scope retainers. Okay, in family law, where there are a lot of self-represented litigants and where there are opportunities to say, I can help you get this far, or I can appear in court, or I can prepare this for you. It makes sense to potentially, it's not ideal, but potentially help somebody move a step forward. It's better than having nothing. It's worse than full representation. It's where we're at. A will is a legal document. You can't parse it out. You can't say, well, I'll disclaim away. It's not like a contract or like an opinion letter, right? You're not going to write this with an opinion letter that says, here's the will. The will only runs based on the following assumptions. 1, you have a bank account at TD. If you have other bank accounts, we didn't think about them. 2, like you just can't set up a will that way. So you can't contract out of due diligence. This is somebody's life. If they want to write a will without you looking at their assets, if they're like, look, I just want to give it to somebody else and I want it to be a 3-line will, let them write their own 3-line will. You don't have to write that 3-line will because that's not what you and your expertise are there for. If they don't want the expertise and judgment, then why are we talking? Why are we here? If they're not going to let you lend your expertise to protect them, then there's a mismatch of interests.
And can you just speak, now I know I've seen the old stats, and inadequate investigation has jumped up 10%, from 33% to 36%. Communication, I often say, you know, I joke because lawyers, we consider ourselves, I mean, that's our skill set, is communication, right? We wordsmiths, we're great communicators, and yet over a quarter of our errors in estates are based on communication. So what are we doing wrong?
Well, I think that, you know, on the communication piece, part of it is around the process management of the intake and taking that information and then applying it to the will. We tag that one as a communication error. You could call it anything, really. But this is an example. You know, Jordy comes to me, and I say, how many kids do you have? And he says, 4. And I say, that's great. And I write down 4. And then in the will I draft, there are 3 kids. You know, or Jordy instructs me that he wants a trust that's going to do X, Y, Z, or we talk about it and we agree that that's the best way to structure this, and it's going to go into the estate plan, into the will. And I forget, and I give him a regular, like, you know, one guy came into my office sort of will. And we've seen that. We've seen where the notes say X and the will says Y. And when we ask the insured, they're like, don't know. And we're like, so what do you mean, don't know? And they say, well, yeah, they gave me this, but then I forgot to communicate it. And then even though you're supposed to walk through the will with the client, sometimes people are skipping steps on that, right? They're not taking that time to communicate effectively, which means they didn't find the error before it's been executed. So that's one example. Another example on the communication is just not walking through the implications of the advice that you're giving. Right? So you're talking about an estate plan, you're saying, here are my assumptions, here's how we're structuring this, does that make sense, et cetera, et cetera. But, you know, sometimes that gets rushed. And so, you know, then there's a claim, you know, a complaint that comes back, what do you mean the will says X? And if there aren't notes about what you discussed, it's just the legal document with their signature, but with their testimony saying, I had no idea what, that wasn't what we had discussed. And then it becomes a credibility battle.
So I want to turn over to Fritz, and these are not unique to estates. I'm sure errors in estates, yes, probably inadequate investigation is, you know, is more substantial in estates, but your thinking is on technology and legal tech. How can technology, never mind estates, but what do you see about technology in the legal sphere? What's the resistance to it, and how do you see adoption and those kinds of things? Maybe if you could speak a little bit about that.
Sure, happy to. I should put up a disclaimer first, though. I'm not speaking on behalf of the OBA, in case you're wondering. So
I am, actually, so there you go.
So my personal views. Well, let me go back to something that Juda said, checklists, right? I mean, at the very basic level, technology helps you build checklists and helps you have the checklists at the ready that you go through every time and that you use every time. Actually, while you were talking about checklists, I was reminded of a scene. You can probably tell I'm German by birth and upbringing. My sister was a flight attendant in the 80s, and I occasionally, as a teenager, got the opportunity to sit on the jump seat between the 2 pilots on a flight that she was on. And, you know, that's obviously long pre-9/11. And there was an American pilot sitting as a co-pilot on the right-hand side, and he was going through all this paper back then. And at one point, he turned around to me and said, Friedrich, everywhere in the world, planes run on kerosene. In Germany, they run on paper. That reminded me of your checklist comment. They work. So yeah, that's the basic. But I think technology is there to enable communication, to enable comprehensive investigation, to be able to do some of that with the client. So if the client enters 4, you don't have to take a note. It's not in your handwritten notes that you have to go back to. You have it somewhere in one source where all that information is, so that when you go to drafting the will, you know that the answer is there are 4 children, and not 3 children, right? So technology helps in those ways. You asked me what I think is there in terms of resistance to using technology. I think we all resist technology for different reasons, and I think lawyers are not necessarily very special. They are special in one very particular aspect, and I'll come to that in a sec. But the way I would structure it is to say, I resist technology because I'm not aware it exists. I'm not familiar with it. I didn't invent it. It isn't useful, or it isn't profitable. So let me talk about those 5 in a row. I'm not aware of it. Happens, especially if you're busy practicing. You don't know. You can't cover everything. You're being asked to, read up on all sorts of things, and then you're supposed to read up on law. You have to become aware of it. One tool Juda and I were discussing, I was impressed to see when we had our pre-conference call, that LawPro has a list of technologies that it just points practitioners to, right? There's no endorsement necessarily in any of that, but it points it to. There are these tools to make you aware of it. Not being aware of it, I think, is increasingly like suggesting I couldn't call you because I didn't know that a phone book exists. That's kind of like, that's no longer an excuse. Not familiar with it is another level. So now you're aware of it, but how do I get familiar with it? Well, can you get a demo, or you watch something on YouTube or wherever where they have a very slick product demonstration. You don't really become familiar with it. You need to take time to actually understand it, talk to other users, ideally. All of that takes time, but it is a necessary step to become familiar with it, to understand how to use it in your practice. The third one, not invented here, we're getting closer to where the lawyer-specific issue is. And the not invented here is, unless I have written it, I don't trust it. And this is especially with technology that incorporates legal know-how, right? And this is technology, so we're not talking about Microsoft Word. We're talking about technology that affects the way you practice as a lawyer. And the more legal know-how is in the machine, the more you're naturally becoming resistant to employing it, because you might not trust that it is doing the right thing. It could lead you to an error, right? Whereas you know what's between your ears, so you know what's in your brain, and you can put that on paper, and therefore you trust that. So that not invented here is a resistance, and it's an understandable one. But again, it comes with endorsements either from peers or other reviews that give you a sense that this is worthwhile technology to explore and possibly employ. I said the other day there was an event, the Law Society has a new committee out that looks at the future of the practice of law, and they asked me to talk with them. And I said, if we had the same resistance, this came to me, by the way, in a moment's notice, this analogy, but if we had the same resistance to technology, to trusting technology that we sometimes do in law, if we had that same resistance in how we make vaccines, there'd be 25 people with a vaccine today. A COVID vaccine, because we would say to them, you can't employ any machinery. You chemists have to sit there with mortar and pestle and do everything yourself, and have to see everything yourself. You cannot use any technology. You can supervise technology. You can supervise computers. You can supervise programs. And the same has to apply with technology. So the not invented here, I think, is increasingly not a valid argument. Not useful. That's where the core of the lawyer is, and the next one, but that's the not profitable. The not useful one is, it doesn't work exactly the way I work. That's really very specific to lawyers. Almost anywhere else when it comes to employing technology, people will say, oh, that makes me 20% faster, or that makes 10% of my work better. I want that. The lawyer is, unless it does it exactly the way I'm practicing today, and puts it out in exactly the font that I devised in 1984 when the first time word processing came out, I am not using it. the format isn't right, and I'm not using it. That's very specific to lawyers. And the last one is also specific to lawyers that bill by the hour. A lot of technology does not lend you to billing by the hour because it eats away at your hours. It's as simple as that. So, you know, it's another reason why it doesn't get used. It's pretty specific to lawyers, but not only. Obviously, there are others that are on a time and material basis engagement. But for those, technology is always a question, you know, do I employ it and therefore make myself poorer?
And the other thing that we see is the amount of time that it takes to adopt new technology, right? I mean, you know, doing it the same way you've done it 100 times is going to be faster the 101st time. But it's actually going to be the same thereafter, right? It's going to take you exactly the same time. But of course, if you adopt technology and spend, you know, the time to increase your speed of things, yes, the 101st and the 102nd might be longer, and the 103rd might be longer, but the 104th and the 105th will be much shorter than the first 100. So, is there anything you can say to lawyers about that? Like, what is that we're doing wrong on that front?
I don't think it's wrong. It's just a question of the urgent versus the important, right? So, whatever email program you use, let's say Outlook, we all probably use 5% of Outlook or 10% of Outlook, especially in a collaborative environment. I mean, when the pandemic hit and the firms that I deal mostly with the large firms, they were all like, oh yeah, we deployed Teams and we're totally in Microsoft Teams. It was like a laughing joke. I mean, all they did on Teams was use video conferences. I mean, basically they'd employed Skype. I mean, what's the technology underneath it? They hadn't really used Teams, and they are now 2.5 years in, starting to think about using it beyond that. So it's hard. So there's no question about it. And the urgent gets in the way of the important. It's important to do that. The urgent gets in the way because you're constantly busy. You always have your desk full with work, your email inbox full with requests. So it's hard to do that. If you're in a collaborative setting, even more so, because now you've got a bunch of egos all saying my way is the best way. And so now you need to find a way. That's another one.
You got to be crazy to be in the software business in the legal field, don't you think?
Well, if you bill by the hour,
I'm speaking from experience. But yes.
No, so the last one, though, that I would say where it also gets in the way is if you're not specialized, right? So you don't get to 101 times of usages if you only need technology a few times. So I'll give you an example. I did, as part of the OBA role, I trialed some technologies, and I wrote a review report. So here, if you're an OBA member, you have access to that. I don't know exactly where you find it, but somehow magically you'll find it behind a paywall that you would have access to as a member of the OBA. And there are these review reports. They're 10, 15 pages long, and they tell you about 3 technologies that I'll mention in a second. The reason I say this is they give you a head start on not familiar with and not useful because you understand the implications of using it, etc. They're trying to give you a guide. You can read them, takes half an hour, should hopefully not be too much time relative to important versus urgent. But the 3 technologies are CiteWrite, that's actually a Canadian technology around citations, especially for a factum, etc. Minutebox, which is around managing minute books electronically, and the third technology is Bryter, B-R-Y-T-E-R, which is very much around document automation and automation of workflows. It's a lot around checklists, but also talking to clients about doing an automated intake, for example, on certain things. The technology I wanted to mention in that context is Minutebox. You have to rethink how you run minute books, if that's a business you're in. But if you're not in this business with some dedication, meaning you do hundreds, if not thousands of minute books, you will not get good at it. It's just a simple limitation. If you just have 10 minute books that you run, you will get 5% of that. I'm sure, I don't know, but I'm sure it's the same with the estate planner. If you use it 100 times, you get better with it. And this is, by the way, not a plug. If you get better with it, if you do a lot of estates. If you only occasionally do it, you just don't use the technology that well enough. It's just a simple question of specialization.
And Juda, maybe just over to you. Where do you see technology, not just in the States, but influencing the claims? Do you see fewer claims against people who use technology? What is, or is there any kind of stats on that? Do you have any sense of that?
Yeah, so technology is always whatever's neat and shiny in the day, right? Fax machines were a cool technology. There's a great letter from one US Supreme Court judge to another in the early 90s being like, hey, I got this machine, you can come use it anytime, right? Like, so generally speaking, the tech adoption hasn't led to significant claims. I will say that tech non-adoption has caused claims, though. So, you know, one of the barriers around legal tech until the pandemic, I would say, was software as a service, right? Friedrich talked about, you know, didn't build it myself. There's another one that lawyers, Canadian lawyers in particular, are very concerned about. Is the data stored on Canadian servers? If not, the US Patriot Act could come in and steal all of my vital documents. Yeah, that is technically accurate. It is a risk. Is it a likely risk? Don't know. So we know that that's a showstopper for lawyers in Canada right now. And that's fine. In fact, on our list of, you know, not endorsed, but just, you know, products that you might consider, we actually checked, I think on all of them, where's your data stored? And we've even said, like, they've told us they're on Amazon servers in Canada, right? So that's one of those concerns that holds it up. With the pandemic, people got used to storing documents on OneNote or sorry, OneDrive or on Google Drive or sharing documents electronically more often with clients. But those who didn't, we've seen claims. So again, not a high risk, but we have seen claims where, for example, wills are destroyed because the originals are being kept in an office that is flooded. This doesn't even have to be a home office or a ground floor office. You can be in a tower. I'm in a tower at LawPro. My first office at LawPro got flooded because somebody above us had one of those coffee machines, but, you know, the water thing wasn't connected to the coffee. It was just going into my office, right? That could have led to destroyed documents. My documents are in the cloud or on our network, so less of a risk. Goderich. You guys remember there was a tornado in Goderich, right? It like ran through the town. The courthouse was impacted. There were wills that could have gone missing. I think there may have been, but my point is that in this day and age, there are risks of the physical paper too. Now, some of you might have one of those awesome safes, and some of you have called and said, I've got an awesome safe, but I'm running out of space, right? Do I invest in another expensive safe, or should I move to the cloud? And so there are some benefits to embracing the tech in terms of accessibility, in terms of being able to interact more frequently in ways that your clients are used to these days, that haven't really led to date, to significant claims.
I'm just going to ask if the audience has any questions for, hang on, I'm going to give you the mic.
Sorry, just about your last comment, considering that we in Ontario still need a wet signature will, I mean, how do you reconcile that with storing stuff on the cloud? It's got to still be physically located somewhere. I know I'm often comfortable dealing with trust companies where they have storage facilities for these sorts of things, but I'm just wondering if...
Yeah, so let's start with you know, not all documents you're necessarily going to want to put in the cloud. There may be key documents where you have a wet signature where you want to keep the original, right? And so wills can be one of those, and you know, there was the virtual power, but you know, a lot of lawyers prefer and insist on the wet signature. So in that case, sure, the wills you will want to do your best to make sure that they're in a safe location. It's okay to seek to potentially outsource that to others who have expertise, who might have, temperature controlled, climate controlled, safe boxes, et cetera, et cetera. When doing that sort of due diligence, you'll want to think about other things like, have they limited their indemnification if something goes wrong, or what happens if there's an issue in the facility? How quickly can you access them? Can you get it around the clock? What's the retrieval time? But generally, there's a lot of other paper in the legal profession, right? And a lot of that can be moving. One of the things we have seen, we saw a couple of claims reported in the shift while people were making the transition from in-office to home. And, a key document that's not scanned is on a lawyer's desk, but the lawyer's gone home to write the opinion letter for a client and misses a document. We've seen that. So you can see that scenario. That is, if the opinion goes out and they haven't seen a document that they should have reviewed, that's negligent. But another reason to call Law Pro is just because you were negligent doesn't necessarily mean that there's damage, right? What if that letter absolutely was a red herring and had no bearing on the opinion, would not have changed the opinion, right? That's one scenario. Another scenario is, darn, that was the key document in the whole thing, right? So it's important to call Law Pro whenever these sorts of mistakes get made, but then we can help you figure out what's happened and act on in your interests without necessarily just folding in the tent because you made a mistake. Mistakes happen, especially in times of transition, but we can eyeball it and help you through it.
Let's try this.
My question is a pretty specific investigation question into a title for a real estate property. So if a client tells us that they're holding title to a real estate in a joint tenancy with someone else, like do we pull up the parcel register for that property and look into it? Do we not trust our client when they tell us that it's in joint tenancy? Or I'm not sure if this is a question that you would be able to answer, or if someone else in the panel can answer that.
So just to repeat that, just in case you couldn't hear online. The question was, what about real estate title documents? If a client says to you, look, we own it joint, do you have to do a title search? What can you do about that? And then I'll maybe ask Ian and Suzana to jump in on it as well. Do you want?
Yeah, I mean, I don't think there's a all right. I don't think there's a standard that is set in this area. I could be wrong. It's not my area of complete expertise. What I can tell you is we have on occasion seen a mistake made on that. And so some of the indicators, if it's two people and there's nothing special about how they've structured their lives, when they say that they're living together, that may be right. The ownership may be joint. But sometimes that's not the case, and even when they really think that's not the case, wherever possible, to me it would be best practice to pull it, right? Why risk it? Why risk it for them? Because we see these claims all the time, where somebody's come and said, no, we're joint, and then somebody's like, oh, actually no. When you set up that business and you were worried it was going to fail catastrophically, you wanted to judgment-proof yourself, and so you signed it off to your spouse, and we never undid that, right? So in their minds, they're joint tenants, but in reality, they're not. So it's better to pull it. But why don't we ask the...
Thank you. I agree, Judah, totally. And I sort of always approach things, as a counsel of perfection, what would be expected of us. And, I think it's always safer to pull it. I know it's a disbursement. I know it's an added cost to an already lost leader when we're talking about drafting wills and, trying to get compensated for the real value that we're adding here. But if the client says, no, I don't want to pay that, or insists that this is how it is, then I think the only thing we can do is just document that decision by them, and the fact that we recommended that we should get full title, they've told us not to, and we're relying on the information that they provided us. I think that's really the only thing we can do in the circumstances.
Yeah, I agree. I think it's a full defense too, quite frankly.
Just another point as to why we check title is in Ontario, we have the ability in some circumstances to transfer property without probate. And you wouldn't know that necessarily without a title search. And so even if it turns out that, yeah, they were right, I can recall, and I'm going to speak frankly to this group and to the people on the web, that I made a mistake where I didn't do a title search, and turned out that, guess what? The property could have been transferred without probate. And I don't know if I was negligent or not. I paid a claim personally because I felt that I didn't do my job right. Wasn't sued, it wasn't any of that, but I cost this client probate tax, and I could have avoided it. And it's the biggest error I've made in 30 years, probably, at least the one I know about. But it can, I felt like, it was just wrong. I just didn't do it. And it's not, I can tell you, I've never done that again. I'm like, I don't care what you say. Do you understand the difference between joint ownership and tenants in common? And they're like, I'm going to do a title search. It's not like you send somebody down there. I pull it up on my screen. And so I'll never waive that again. Even when, it didn't have to do with title, it had to do with, the property. So I'm sharing that with you. You don't have to repeat that to anybody, eh?
But this is the thing about these claims, right? When you're dealing with risk, that one falls within the realm of the very, very possible, right? Like, this isn't that one.
Thanks,
in a.
Juda. Thanks.
No, really, this is the sort of mistake that really can happen, and it can happen when we don't. We might have skipped over a step in the checklist. We may have said, okay, well, I'm not going to raise this because this client is of limited means. Well, you still should raise it, right? And as Jordan's right, I don't even remember first year law school and JT versus other, and forget it. I'd be pulling that for myself. I'd want a lawyer to pull that for me. And if you can't, then absolutely, like, the documentation is everything there, because you can't just, and this goes for everything around wills, you can't just make those judgment calls for the client without them, right? If there's a risk area or something that you're supposed to normally explore and you choose not to for whatever reason, you at least need to have the client sign off on that after a discussion of the risks, and then document that decision.
Other questions?
Hi, I'm a wealth planner, work with high net worth, ultra high net worth clients, reviewing wills on a regular basis. Recently noticed quite a few times when commissioner commissioned their own affidavit. Is that okay? Like, few times I don't know. Commissioned, like they tell that I'm a witness of the will. Affidavit. Is that okay?
So I think the question is that the witness also commissioned the affidavit. Is that right?
Exactly. Their own signature.
Yeah. Well, they cannot commission their own signature. That we know. They could commission someone else's signature even if they were a witness, but you can't swear an affidavit as the deponent and the commissioner. So if you see that, you got a problem. It can be fixed, though. It can be fixed. The will is fine. The will's valid. Yep. The will's valid. You just got to get a new affidavit of execution. That's a good one, though. I haven't seen that one in a second. There you go.
Hi, my name is Otto, and I've specialized in criminal law. And in my 20 years of criminal law, I've never ever seen wills in the States come into criminal court. But I have seen silly little contracts worth about $50 for prosecution. But what I'm saying is, wills in the States, it's a lot of money involved here. And I know there are some people who try to do forgeries and fake wills. And there is no specific provision in the criminal code which deals with this sort of stuff. It's considered civil law. I think the only one would be forging or uttering a forged document. That would fall under there. Is there any treatment of criminal activity in civil court that deals with false? Is there any repercussions for people who get caught forging a will after a civil case? Thank you.
Over to you, Ian. You may have had a few forgeries in your day. I've seen some.
No, just my trust account. I know. It's a good thing there's 2 signatures required. No, so forgery in the crossover of the criminal. First of all, I'm pretty sure there's a provision in the criminal code that says you can't destroy a will. I'll double check that, but I'm pretty sure there was. I thought there was years ago. I remember looking at that. But fraud is typically treated with a issue of costs almost always, and it is rare. And it's rarely pursued. When you do get into, and we do bring the criminal counsel involved, and lots of times over the years, you can bring in criminal counsel and get the police to look at charges through the fraud provisions in the criminal code. So that's really the first starting point. Suzana, did you want to?
And I was just going to add, and we've seen recently some cases with power of attorney fights and criminal proceedings brought against attorneys who've acted inappropriately. So there are opportunities where those kinds of remedies can be sought, but again, it comes down to a question in many cases of damages and what can we do about it civilly and what can we do about it criminally.
So we're going to take a little break, and then we're going to have time for questions, so there'll be more time. We're going to take a little break, and we'll be back around 5:15. And so please enjoy. You guys can't enjoy it, but please enjoy pizza, charcuterie, wine, beer, and say hello up here. And then we'll have some more questions. Then the second part of the program is really error prevention from a solicitor's point of view. Ian and Suzana are going to take us through some preventions. We'll get Juda and Fritz's views on that as well. Thanks so much. We'll be right back at you. Thank you. All right. So I'm just going to get started here. And so what we wanted to do is talk about some practical, I'm just going to call this up for a second, and then I'm going to share my screen. Now, Juda, you haven't seen this, but you don't have to comment. So we've, and I'm going to kind of turn this over to Ian and Suzana a little bit, but what we tried to do here is look at we took your data, Juda, we put it in a blender, and we just wanted to address some things that we think technology can help with, and identify the errors that we're making, and I want to talk about inadequate investigation. And Ian and Suzana, you guys do lots of work with LawPro, and give us some tips, if you can, on how not to fall into the 36% group here about inadequate investigation.
Well, I guess we all have our own tricks and our own sort of abilities that we've honed over the years to engage our clients and be engaged. Still not working. I think part of the struggle is being engaged, and I'm old and tired, and I've heard every story, and there's an estate plan in every situation that I'd say, okay, I know a little bit about that. And so as we get into this process, I'm constantly thinking of ways that I can engage myself and I can engage the client, because that is what enhances the communication. As soon as I get interested, I'm engaged, they're engaged, and you want to find out. You actually want to draw information out of the client. And it's an old trick that my dad taught me years ago in the sense of, look for something, and this is just one of my tricks, and we'll hear from Suzanne, but one of my tricks is I look for something we both have some common interest in. And I try to draw that out early in the conversation. It does two things. One is that it gets me engaged, gets the client engaged, and secondly, it actually starts a conversation as opposed to a rote checklist review. And I think that's where we can get into real trouble, because the rote checklist review isn't interesting to us and it's not interesting to the client, and you're not going to get the information you want to get out of it. So whatever I can do to start the relationship on a basis of a human connection is one of the first things I think of when I come in. And I always think of it as I walk into a client meeting. And now, obviously in Zoom, it was a little different, and it got a little bit rote and it got a little bit tiresome. But I'm finding more and more of my clients are coming out. So that's just one starting point to the communication problem and I've got lots of other ideas, but let me start with that. Suzana?
And I agree with that, Ian. I like to do that just to get to know the client, to make that connection, because this is one of the most vulnerable times in their lives, meeting with a lawyer many times for the first time. And it also helps me sort of try to keep my client straight. So if I can remember something about a client, it helps, when I pick up that file, it's like, oh yes, this is the one who's, just put his cat down or something like that. So it certainly helps. And then it leads into that very, invasive going through the checklist and asking all of these questions that people don't necessarily haven't even thought of, don't understand why you're asking it. It's very, very, personal. It's very deep. And so it, but I can't be without my checklist. As much as I might like my clients and go off on tangents on discussions, if I don't have that opportunity to be able to say in the future, this is what I always do, this is what I always ask, it's the only way that I can build my credibility if there were to be an issue at the end of the day and, something having been missed.
This is, before technology, I didn't use family trees, but Juda, family tree, for me anyway, family trees are, I think it's me that's causing this problem. Family trees are kind of crucial. I've had situations where I created the family tree based on what I thought the client meant, and when I put the kids below the two of them, they're like, oh no, that's not my child, that's my spouse's child. It's a theme I'm gonna maybe mention a few times tonight, but visualization, right? Client actually seeing it is different than them describing it to you in the words, you catching those words in your brain, translating them down to a piece of paper. Anything you want to comment about that?
Yeah, first off, these opening remarks about setting the tone with your client is vital. It's a trust relationship, right? And the checklist can start with stuff like set rapport with client, right? This is one of the things you should be doing, but it's really important that we have that opportunity. And then the checklist itself doesn't have to be rote. In fact, it shouldn't be rote. There's a book called The Checklist Manifesto that teaches us why checklists work and why even the most sophisticated things like heart surgery follow checklists. It also talks about how we can get the most out of checklists, how it's used as a prompt, and it's not just a checkbox exercise. It's there to help us with our cognitive load. If I'm a first-time will lawyer and I'm trying to figure out a family tree, or I'm trying to ask lots of open-ended questions, and I'm in the back of my mind trying to think of the next question, how am I listening? How am I absorbing? How's that interaction going to be going with my client? The checklist makes me know that I'm not going to miss anything. And that frees up the cognitive space for us to engage with the client. Another way to engage with the client is by using visual elements. And that is one of the things I personally really like about eState Planner, is that, and LawPro doesn't formally endorse any specific technologies, but there are aspects of technology that clearly would help when used appropriately. Being able to visualize your assets, being able to see on the screen your words being put into a pictorial form, being put into a spreadsheet, shows that you are dialoguing with your counsel. It helps some people see their life's work, see their structure, and catch errors in ways where just a face-to-face conversation or a Zoom-to-Zoom conversation, it might be like, got that? Yeah, on we go, without actually understanding in the way that it may be visualized. The family tree is great, by the way, because you can see that there are lots of generations. There are opportunities to have blended families, different types of family structures. I don't know if we have like a different color for non-binary or these sorts of things, but this is a fantastic way to show people back to them that you understand them and that we're going to build something together that's really going to reflect them. It shows the value of that conversation with the trusted legal expert they've come to.
I'm going to ask Suzana about, you raised a very interesting point, Juda, about when we're interviewing clients, always thinking about taking notes, trying to remember the next question. Oh, they told me that, I better remember this. What about recording those meetings? I personally do that. I record my meetings. I don't have to, I'm freed up, as you say, not to take notes. I don't know, like I used to take notes and I remember how I did that, but I never took very great notes because it's hard, right? Suzana, what do you, and Ian, you can jump in on this as well. What do you think about recordings with clients? What do you have? I mean, not many people do it, but maybe just jump in on that.
Absolutely, Jordy. You're right, not many do, and there are people who either do or they don't. And those who don't will criticize those who do, and sometimes vice versa. But from a litigation perspective, when we're dealing with these kinds of situations and we're trying to demonstrate that someone did have capacity, that they were not unduly influenced, sometimes that recorded or that video evidence is the very, very best evidence possible. Other times, though, it could be twisted and turned, and counsel could be criticized for being too leading. The client could be criticized. The testator could be criticized for talking too much or looking nervous or looking off camera or stuff like that. So it's really a personal preference, I think. And once you get into it, you do it all the time because if you are recording, that someone's going to judge you with the benefit of that recording, and you're going to do your very best. And the reality is we're all human. Everyone's going to make a mistake. And even if we don't make a mistake, someone will accuse us of having made a mistake. And all we can do is our very best. And, well, if it's recording because it makes you feel confident that you've opened up that time for these discussions and other, cognitive abilities to do other things, then by all means, I think it's the way to do it. And we just have to live with the fact that we did our best.
Ian?
Yeah, it's always terrified me. And I just came out of a big case that we had a recording where the client talked to the doctor and basically she wasn't a lawyer, and she talked to the doctor trying to get the doctor to say that, oh, you remember Jimmy was capable and things like that. And it took about 15 minutes of leading questions. And at the end, the doctor, I think, just kind of got tired and said, yes, I think he was capable. And so I listened to that whole 15 minutes and I'm thinking to myself, it's a skill that we're actually intuitively very good at. And that is, we know what an open-ended question is. We know how not to direct their clients to the answers. And so it's a skill that I try to record more to continue to develop that, because you're a better lawyer for doing it that way. And so I've actually forced myself in litigation files. I'll say to my clients, especially clients that are elderly or in a complex situation, I'll say, listen, I'm happy to record this and send it to you. I've got the Zoom feed that they type it all out for you and everything. It's all magic. The technology is incredible. They get a written version of our conversation, and you can also listen to it again, should you be interested in hearing about the second part of it or some part that you're going over too quickly. So a big part of technology is, at some point, we've got to accept the fact that it is over in so many ways with all service providers. It's over. Like, we are not going to be the same. We're not going to hold the same market position. We're not going to be able to do the things we're doing in so many respects, just as law, as accountants, and everyone. And part of it is I'm looking for opportunities to A, be a better lawyer, and B, to provide better service. The better the service, the more referrals, all of that tips along. It's not magic. And so I don't think that the recording is really a debate. It's eventually just going to happen. I mean, people are going to have a camera in their lapel. They do. I mean, I've been recorded secretly lots of times, and makes me crazy. But I know people do it. But you know, at some point, we're just going to have it in our glasses and just sit down. We're going to be talking, and they're going to be recording. So these are skills that we actually we're ahead of the game on it. So we should be developing it to turn our service industry into the better service industry that it has to be, because it is a fast race. I mean, I was on a call yesterday with a company in Australia, and the stuff that they're going to do to change the practice of law, and I saw their betas, like this is coming, and the stuff that you see in eState Planner, of course I'm excited about it, but your stuff you see in a lot of these technology tools, it is so over that if we can sit there and use the skills that we actually have right now, in things like knowing how to properly interview a witness in an intake for a litigation or an intake for wills, and be proud to be recorded doing that, we're just going to be providing better service. It's all going to be added value. So I'm just trying to get better, and those are one way to get better.
Just think back, pull out an old file, look at your notes from, I don't know, 7 years ago, and try to recall how that conversation went and everything that you talked to the client about, and how you talked about joint tenancy versus tenancy in common and trust versus absolute, and there's no way that's in your notes, not a chance.
The other great thing about it is if you run a firm, then you can use detect and correct. You can use video to actually give meaningful feedback based on evidence, right? How many firms are there where you take the associate aside, or the partners talk to the partners and say, you did this part really well, you know, next time, let's think about how we would consider framing that differently. Or, hey, that was a really neat piece that you did there. So as a training tool, absolutely it's there. Of course, the client would need to consent. Not all clients will. But to make it an offer means that it's another way of showing trust, right? If you would like, I can record this. And so you will have a record of it. And you know, just to get back to some of the stuff that Ian mentioned, because he went fast, but the review is really amazing. You can review some of this and change your speed. So if you're an audio learner, you can put it into 2 times and hear yourself as a chipmunk, but you'll get that information. So there's lots of power here in being able to watch verbal cues and expressions, get the transcript, use that to confirm your recollection. And to see yourself right there in the meeting, and it changes everything from how you're asking a question to body language, tone. It's very helpful.
Wardrobe.
What's that?
Wardrobe.
Wardrobe. Yeah. Well, yeah. I'm hopeless on that one, but let's go on.
I've never thought of it as a training tool, but I can't tell you how many times I've gone back, if there's a delay or something, and I can't remember what did we even talk about. I'm sure anybody in this business has done that, where they're like, met with the client, I see my notes, I'm like, I don't remember what we discussed. The fact that I have that recording, I can search and Zoom does an automatic transcript of it. I mean, it's fantastic.
I mean, litigators get this training because you get a transcript every time you go and do the examination, right? You might not get the video if you went to court that day. I've done the video. I'm on video a lot. I think right now even, right? Like someone's recording me. But I unfortunately get to rewatch that stuff, but it does make you better at what you do. And so having that opportunity of that, real client experience and being able to walk that back and assess yourself critically, constructively, productively, that's a real benefit that we haven't even started to fully take advantage of yet in our own firms, in our own practices, but I think it is one of the real advantages.
I want to turn to one of the areas we didn't really talk about, which was errors of law. And I think estates is belittled a bit by some of our colleagues, by the public as well, about how complicated estate planning is. And even simple, and we've talked about simple and typical and all of those, and I think you're going to see, as complexity increases, the errors of law increase. Ian, maybe, and Suzana, the two of you, maybe Suzana jump in first. Errors of law, is there a way to prevent that? Do checklists help in that situation, or what can we do aside from attending our webinars and things like that, and education, but Any thoughts on errors of law reduction?
That's a good question.
Like, for example, I think errors of law would be things, I'm just thinking of a case that you've had with, PCOR situations or those kinds of things. I mean, there's communication aspect to that about asking the questions, but also the idea of, the legal aspect of that.
Yeah, absolutely. I think, and certainly the inadequate investigation ties to the communication, which ties to these kinds of things because, for instance, dual wills, right? Making the investigations with your client to see whether or not you should be recommending 2 wills or more wills when we're looking at those kinds of situations. Joint ownership, for instance, those kinds of scenarios can become real traps for errors that arise because we are not necessarily properly documenting intention. And that comes because we haven't delved into, what exactly did we mean when we created these joint accounts or, put assets into joint ownership. So, there's so many illustrations of places where we can come into these kinds of things. And the reality is a lot of it comes from experience as well. Like, we're going to make initially errors that, hopefully we'll learn from. And, it is education and a lot of it is supervision, certainly when we're starting out and we need some guidance and some substantive knowledge is definitely important and helpful.
I mean, that's the thing where it's all, everything's in our head, right? We got to fill this brain with, and mine is tiny, and so we got to fill this brain with all this information and have it all work together to avoid these errors, right? Ian?
Yeah, and some of us in the room, though I was called in 1990, so I didn't really live in this era, but some of us in the room remember succession duties in the 70s. And it was like dancing on a pin, trying to calculate tax owing and all of those, the rules were complicated. Well, we're kind of moving into that with probate tax in its own way. It is becoming its own life cycle of effort. Probate tax planning is, first of all, when you get a claim and you have to call Juda, which I've had to do many times over my career, and if you get and that claim is acted on, and Juda doesn't have to tell you all this, but it's like $17,500 out of your pocket. Okay, if you got a trailer fee and you've got the deductible and all of that, a claim is real money out of your pocket. And a probate tax mistake alone, you could hit $20,000 for a probate tax mistake like that. Okay, and all of a sudden you're thinking to yourself, okay, I got a claim for $20,000, I can't get out of it because I didn't do a proper analysis of the probate tax. I didn't put a joint account in a secondary will, which I probably should have, which would have avoided the probate tax, and I would have saved $20,000 for the client. Now the client's all mad at me, I'm getting sued. I don't really want to make a claim against LawPro because that's going to hurt my trailer fees and all that. You get these complexities are there, and so the growth in the substantive knowledge is going to get. It's just going to get worse as opposed to getting better. And so I look at that and I see little things like everybody sat around and said, these secondary wills, these are the greatest thing in the world. But every time you look at one of those situations now, you have to reevaluate all of the probate tax analysis for which a lot of us aren't even trained for.
So that's actually exactly where this comes in, where a checklist helps you because, so first off, in terms of the knowledge transfer, like lawyers have a lot of skills. We were just talking about interviewing skills, right? The substantive skills, like what to ask and for what reason, those are substantive legal issues, but then there's skills in order to get it, right? And so to be a professional, you have, competencies, including knowledge and skills and practice, and it's applied in real time. So if we could take some of those questions to help us guide and focus on asking the questions, those checklists can also help us so that we're not spinning about, oh my God, is this going to get too complicated for me? Or am I hitting something that's outside of my skill zone? So when we think about this complexity, one of the things you can build into checklists is a stop point where you're looking at the visual or you're looking at your information to date. And if it starts to say, hey, there's a tax question here, I'm stopping and I'm getting help. Because when we look at errors of law, one of the biggest issues we see is around the tax advice, because that is complicated and it's always changing and it's super technical. Now, I'm not one of those people who thinks lawyers can't do math, But I am one of those lawyers who thinks sometimes some lawyers don't want to do math or can't do math. And there are some lawyers who say, I really don't want to be the person doing the math. So if you're one of those people, either not interested, don't have the competencies, don't feel confident on the tax laws, or don't want that headache, bring in your tax partner if you're in a firm, or bring in a financial planner, tax lawyer if it's needed, and make sure you're communicating with your client about who's doing what. Then in terms of the error of law reduction and communication error reduction, if you're able to share the data, then you're able to talk about who's doing what, when, why, how with client sign-off, and that reduces that error of law risk around taxes.
And one of the great things, I mean, when the errors of law are usually one of two things. One, you didn't know the law, and two, you didn't spot the problem. And technology in all different areas, not just eState, but all areas, that's where technology can help. I mean, it knows the rules, it knows the data, it can remind us of those problems. And then we bring in, consider this tax problem. I don't want to consider it. Great, let's get somebody else in here to do that. So, Ian, anything else on that?
No, I think that's great. And I will say, I mean, that's one of the great things of advisor alerts that, you sit there, you need to advise yourself, right? You need to remind yourself what can you use, what tools can you use to trigger the reminders? And obviously that we talked about whether we do a sub search for entitled to a property, that question, well, these are things that you can build into either checklists or through using technology.
I want to take some questions. So did anybody there were some questions from the last time, but are there any questions about error prevention from what we've talking about on this side so far? Okay. Fun? Well, but they won't hear you.
Oh, sorry. Thank you. So
you
just
need to introduce yourself, Jonathan.
My name is Jonathan Morris. I'm an estate planner at BMO.
No, you're the director of estate planning at BMO.
Thank you very much. Thank you for marketing for me, Ian. Just on when client comes in and you do the title search, so we talked about looking for title, confirming that. Are you also pressing them and all the other assets that they might talk about, investment accounts, that sort of thing? Is there equal pressure on that score to ask them for those, the documents behind that?
Yes. Yeah. I mean, if somebody says that they've got, key assets that are going to be material and that, people might feel like fighting over later, you want to make sure, right? And I talk about, we're in an unfortunate wave right now where if you look at your retirement savings, they may not quite look like where they were in January. So when you ask somebody, what's there, and they say, well, I think it's 100, and you say, okay, and where's that account located? They may not actually have it all right. And I can tell you, back in my litigation days, I mean, one of the first times I got burned by a client, because it does happen, let's just be honest, right? Is where the client wanted to sue for negligent investment advice. And the first question I said is, great, can I have your documents? Sure, here's how they were at this point in time. Yeah, that's when the market was at its lowest. What can I see after that? And the answer was, what, you don't trust me? And you know what, that's a red flag, right? That's just a red flag. I trust you, but if the market fully recovered and there was no harm here, then I gotta be able to see that, right? And that's litigation, but it's similar in wills, right? A client is telling you they have certain assets and it's gonna be divided a certain way. If it turns out that, one of their things that they're trying to equally divide, but sort of in different ways, if it turns out that, let's say child A is getting the Porsche and child B is getting that bank account, right? And they think in their mind they're equal. And you're like, well, they told me that they were equal and you didn't check? I mean, that's gonna be a hard one for us to defend, I think.
Yeah, and I think there's that balancing act too, is report it out. If they won't give it to you, and they don't give it to you, because lots don't. I mean, it's like checklists when you send it to the client in advance for wills. I mean, they barely spell their name right? I mean, they just hate it. That onboarding work they hate it. And it's very difficult to get this kind of data out of a client. So as long as we've asked and we report it out, it's a big part of it. And I can tell you the reporting out is a fatal blow almost always. It's just you're not going to get in a situation where, I mean, I can't guarantee how judges will behave because, they'll all be different, but.
Okay, so I'm starting from best, right? But the standard is reasonably prudent. And so I agree entirely. This is like, I think the second time where I started with best on, ask and try to get it. But if you can't get it, communicate, document. I always talk about it, we're going from the 1890s to the 1990s, compact discs, right? CDs, they spin. I've said this at a few places, but the music is from the spinning, right? And so when you have a communication, you want to think CD in your head, spin like a CD, communicate, document. So if I had a phone call or if I had an in-person non-recorded meeting, I want to make sure that we've had the conversation and then I've confirmed it in my notes, I've confirmed it in writing. It can be a very simple thing. Hey, thanks for meeting with us. I saw in your intake that you filled out A, B, C, D, E. We discussed, I asked for and explained why we need F, G, and H. You said, not interested. I'm assuming based on what you've told me the following, I'm going to draft accordingly. There it is, right? The risk goes back to the other side.
And I just wanted to add the easiest illustrations of that are like beneficiary designations, when clients tell us how insurance is designated, how it's owned. And the other one that always scares me is corporate ownership. Right? Oh, I have a company, or I have shares, or they treat it like their own bank account, and there are perhaps other shareholders, right? And so those kinds of ones are the easy, low-hanging fruit in terms of inadequate investigations. If you're not pulling in this information and not verifying it, then I think we just leave ourselves exposed.
Just to address reporting letters, I know when you have a Law Pro claim and they're investigating, we've acted for Law Pro, and first question is, was there a retainer? 2, was there a reporting letter? And 3, were there notes, right? And again, technology can shorten that, can do a retainer like that carves out the stuff that you're not going to be doing. And a reporting letter, I'm just showing you here, you raised the issue of designation of beneficiaries. If you're not going to deal with beneficiary designations, then the great thing is technology can help that and say, in accordance with your instructions, I have not included designation.
And will software takes away the guesswork there, because we have seen and continue to see those errors where somebody's marked something in the notes and then the will was drafted differently. And that piece gets automated in most will programs, right? All will programs, and so that key error around drafting and around miscommunication, or however you want to describe it, gets addressed if you're properly using a trusted legal tech.
So just turning then to drafting errors for a second, that fits into all kinds of things. One of yours where there's the disconnect between the instructions. I know Ian, Suzana, we've all seen that. Like the notes say something and the will says something else, and then the lawyer says, yeah. And there's not much we can do about that. Rectification doesn't necessarily work in those situations. What can you do from a litigator's point of view in defending those claims? How do those go?
Well, I'll just use 2 illustrations. One is the classic doesn't add up to 100. And so litigated over that. Numbering's off in accordance with paragraph 6, sub C, sub II, large capital A, III. You get into a situation where you're just walking into trouble. And so what technology can obviously solve is the numbering. Proper technology will solve the numbering. But second of all, whatever precedents you're building in your own practice, an overabundance of subs and A's and B's and C's is always a nightmare for litigators when we're defending it. So just think about your work product. We can't plain English wills, and people love to say that. I mean, I don't care, actually, maybe we will someday, I'll probably use those words, but, you know, these words have been hucked around for 600 years. Like, people have been saying what the term issue means for a long time. Where you put it in the sentence really does matter, but the word itself, you know, except for Justice Cullity, who bounced around it in the last 25 years, it's kind of locked down. And so we don't want to get into situations where we're turning wills upside down in terms of the language and turning it into some sort of exercise of plain English too much, but we also want to look at our work product and think about, is this a simple presentation, not necessarily for the client, because they're never going to see it as simple. It doesn't matter how well you do it. Is it going to be simple to explain to a judge?
I think the other easy one to want to definitely avoid is the logic tree kind of thing, where we're talking about different situations, different scenarios, different, you know, if this, then that, if this, then that, and then we forget that there's this catch-all situation here, whether it's residue or something else. When we've got the benefit of technology, we've got the benefit of a second look at these things, we can, you know, map out those different alternatives in a way that, you know, hopefully we're avoiding that hole.
I just took a call, not a will, but you could see how it could happen, where it's the if this, then that. So client may have thought already about if this, then that, and you're like, great, right? But you're the person to give them the extra mile, because they're not going to have gamed out everything. And we've seen that all, right? None of us expected a pandemic. No one, you know, there are things that happen that come as surprises, and we need to try to game those out as best as possible. But what happens is when it's in the moment, or where you haven't decision treed it out based on your best experience already, then you might miss something. So we don't want the tree that's just a shrub, right? And a checklist helps you get all of the points. And if the decision tree takes you to an end point, then fine. But that one extra open question might open up a whole suite of other questions into your checklist. And so that doesn't have to be, by the way, none of this around checklists and around templates and around numbering and about all of that necessarily has to be in a software as a service product. I mean, there are ways of doing this using your existing tech deck. If you have Microsoft, you can build this yourself. Some of you may already have that, right? There are all sorts of ways to do this, but it's more about the mindsets that tech has brought into legal, where we're starting to say things like decision tree, right? But recently I took a call where the decision tree was, well, the urgent issue was X. And what that really meant was they decision treed out X, but they punted every other issue to another day. And guess what? When I got the call, it was that other day, right? And so you need to be there in that moment, and that client may be thinking of the most urgent part, but your checklist will help to make sure that you're doing the follow-up work.
I think the idea as well that is the checklist is dynamic and contextual, which is what tech can do, right? I mean, it can produce the right check questions based on what you've done before. And that example that you had where you went if, you know, if then kind of, and you missed it. That is so easy in our business, right? I mean, we often, especially if the client has told us, well, if this happens, then that. So we just assume that that's the last answer. But what we have to do is ask one more. And if that doesn't happen, and in our business, I mean, we have the hardest business, I think, because we need a crystal ball. We don't know what's going to happen when this thing kicks in 20 years. And we got to sort of predict all the different possibilities.
So that's decision tree logic. Another one, which Ian just mentioned, is it's the add to 100 logic, right? You know, I tell my kids, give it 120%, and they give me an eye roll, right? And your clients would too if their, you know, total assets went to 120 or went to 98, and where's the 2%? That's my dad about my, you know, why didn't you get an A+, right? But you're aiming for 100, and a checklist will help you get there, but you have to make sure that you're not letting the checklist run you. I've actually seen a claim come in, and this is quite some time ago, but it was on a real estate transaction where they knew there needed to be a reconciliation. And so they made it reconcile, right? You can make a chart reconcile, right? But that's letting the process lead as opposed to your knowledge, skill, and judgment. What that should have been was a red flag. It's not adding up. I'm not going to create a new column called, you know, reconciliation and put the exact amount that the fraudsters had taken out to make it all add up.
I mean, who hasn't done that in an estate accounting? The things that we know it's there, it's somewhere, it's off by
A book entry.
a book entry to reconcile. But that's right, it's a red flag. Something went wrong. Something went wrong. We just have a couple of minutes for questions. Any questions? Sure. It's not about commissioning, is it?
Hello, no. That's another real life. So I have a client who's in his 80s, and he has his will, Family Law Act clause in the will. And what happened, he a widower, and his daughter lives in his house, and with her husband, no children. So there is no agreement. And what happened now, his son told me there is a problem with his daughter, and she would like to claim a part of the property for her. And I heard from my friend, lawyer, that there are some cases going on. What the guy should do to prevent, or maybe the lawyer didn't ask him a proper question, I don't know. Is it possible to that daughter-in-law, to that in-law to grab a property who owed 100% with the father who paying for everything?
So that's a question about, I mean, if you investigated this and asked about the family relationships, I mean, one of the things on our checklist is somebody living with you, right? And that gives rise to dependent support claims, et cetera. So it's on that checklist that we've got to deal with. Yep.
Thank you. This is a great session, by the way, and eState is a fantastic product, so that's my endorsement. You get another charcuterie. Yeah. No, honestly, it's fantastic. But there is this tension, right, between the amount. I can't get a client meeting done in an hour. I can't do it. It's not possible. So we're, typically an hour and a half. I record them for the most part. But there is this tension, especially on the data collection. Like you could jeopardize a client getting a will done at all, right? Yeah, so that's on the one side. You could be saying, well, I'm sorry, I haven't seen this. I'm not going to proceed until I see. So I think that the ability to balance, to try and say, this is what I'm not doing, and you've agreed, et cetera. But the other tension is, is the compensation. Like there is a challenge, some of us say we'll have a flat fee for a very basic will. And then as things become more complex, which they often do, there's this tension about how do I do a proper job and still, make a living doing this stuff. So it's tricky. So what's the answer?
All right. What is the answer?
Well, in terms of the process, I look at this sometimes in I don't know if you've read Jack Newton's book, but Jack Newton is the CEO of Clio, and he talks about client friction, and we want to reduce the friction experience, right? So one of the things that tech and client portals can do is make it easier, perhaps, for clients to share documents, right? And I think that going forward, I mean, we're still in a paper to scanning era. So I think for the foreseeable future, it's a tough one, and I'm not gonna belittle that challenge. But I think on the go forward, a lot of people are gonna be able to upload documents electronically to electronically fairly easily, and it'll become the expectation. So on the longer term, I think that's going to settle itself out, where it's going to become like, oh yeah, you've got all these documents. Of course you need these documents. You're preparing my estate or my will. Here you go. Let's get in this, right? For now, I think there's a legitimate friction point. Certainly people in the financial industry setting who are doing estate planning or other financial professionals who work in similar spheres to the wills and estates bar find this to be a tremendous problem. So all I can say right now is I understand. That's why we ask, we try to explain, we gently cajole, and then we disclaim away in writing clearly that we asked and we think it's really important, but you've told me I'm not getting this stuff. In terms of the pricing and where it goes, I think that part of this will come to our expertise. So if you're a wills lawyer and this is what you do every day, you know better than your clients walking in on average how long those meetings take, and on average, based on your pipeline or your referral networks, what type of complexity these wills and estates are going to go into. and what the tolerance will be in terms of the value of an estate, the value of somebody's, life achievements, what a reasonable fee could be for that will. That's a tricky thing if you're dabbling to get into the habit of doing. That's a really tricky thing if you're a dabbler to try to figure out. But for the true experts, and this really is expert work to do a will, then, we have that data, and we could be using that data if we're thinking of doing flat fees so that we understand where the risks are, and some of them might not add up, where it might not have been as profitable, maybe it wasn't profitable, but if we know exactly, the range of hours per file on average that it'll take, and again, it's an on average because we'll always go and get it done, then we're able to price that in and, quote to clients based on that sort of estimate. So I think that's where we're heading when it comes to the fixed fee, or where it comes to a fixed fee plus an hourly above.
Yeah.
I just want to jump in on that one point. I mean, the time it takes is the real lawyer's work, right? If you can reduce the amount of non-lawyer stuff that you don't waste time on, I mean, that's how you make some money on it, is by not wasting time on stuff that you don't need to waste time on. Yeah, always use a range for fees. You should basically, the point is adding up all the emails. I mean, that first, if your first exchange with the client has 14 emails in it, double your fee. Ian.
This is gold. I mean, Jordy's one of the guys that actually can earn a living doing wills, and it's remarkable to me. I think we have to be realistic, though, and this is why Jordy and I are so passionate about technology and the estates here. This isn't there's no easy fix. It is a cultural thing. It's a cultural across all English-speaking, the Commonwealth. There's nobody you can talk to in New Zealand, Australia, and in England that don't say the same things. We cannot price wills properly. It's not going to get fixed. I'm doing this for 32 years. There's not going to be a magic wand. The only way we can do it is the sorts of things like just tweaking it, getting the lawyer's work, getting your time, making sure you're using your time and let something else do the other time. Because there's just, I don't care what people say. It's not like people are going to start waking up and going, this is the greatest thing in the world. I want to double everyone's prices. It just isn't going to happen. And so it's just the same with real estate. I mean, it's the problem with real estate. So I don't want to be a defeatist, but I think that's the reality. Suzanne?
And I was just going to add, I think we have to build efficiencies into this. And the easiest way to do that is with technology, right? And so there is a cost of learning how to use technology. And that's what many people are shying away from, because, it takes a long time to get really good at using something like eState. But once you're really good at it, it just makes you more efficient. And it opens up that lawyer time, makes it more valuable, and makes it easier to become hopefully profitable in drafting wills and estate plans.
So I just wanted to note that it's 6 o'clock, and so I want to thank everybody we're going to stick around, by the way. For those of you who are here in person, we have a special gift. We thought that everybody could use an extra exhibit stamp. So we have a branded exhibit stamp, and so you can get that on your way out. Please stay. We're going to stay up here for a bit. If you're on the web, thanks so much. If you have any questions for us, feel free to reach out. And thanks for being here, and we hope to do this again. Thanks, everybody. Thank you. Thank you.